Now I give the floor to Mrs. Pantopoulou, who is a case handler at DG Comp, one of the most, let's say, distinguished scientists, apart from her institutional position in the field of state aid. I had many times the pleasure of actually understanding that and seeing that. And let us now concentrate, and I think that she will do that in her analysis about uh, practical issues such as recovery of unlawful and incompatible state aid, and the implications of this necessary mechanisms. Ms. Pantopoulou, you have the floor. Thank you very much for being here with us.
Good afternoon. Thank you very much, Professor Metaxas, for your kind words and for the invitation to present today on recovery. I have a presentation. So I understand this is the last presentation for today, and we will look into recovery of unlawful and incompatible state aid. You already know that the energy sector is heavily regulated and relies on mechanisms that can be qualified as state aid. So it's really important to have state aid compliance. And now we will see also what happens when we don't have compliance. So I will start with an introduction that state aid control exists to prevent distortion on the market. So when member states grant selective economic advantages, and you have already heard that advantages can take different forms, fiscal measures, grants, so all this be notified to the Commission unless there is a clear exemption of notification. So when state aid is granted without notification to the Commission, this aid is unlawful. When the Commission assesses aid and cannot approve it, then the Commission orders recovery of that aid. And I want to stress out from the beginning that recovery is not a punishment to companies. Is a way to restore competition on the market. So let's start linking into specificities. First, we start with the legal basis. So the legal basis is found in the Treaty on the Functioning of the European Union, Articles 107 to 109. This article set the rules. State aid is prohibited unless it is approved by the Commission. I want to really point to Article 108, paragraph 3 of the treaty. This article contains the standstill obligation. So the standstill obligation is a technical term that we use when aid is granted. That actually says that aid cannot be granted without approval. So granting aid before the approval is unlawful. The procedural regulation is a regulation that says the procedure the Commission follows and how recovery works. Case law of the EU courts, of the Court of Justice, actually the origin of recoveries is found, the origin is found in the case law of the Court of Justice. The union courts have consistently heard that member states that have granted incompatible aid have to abolish these measures and need to re-establish the previous situation on the market. And last but not least, I want to refer to the notice, the recovery notice, as we say. It's a notice published by the Commission. It's only binding on the Commission, but it sets the rules that the Commission follows as regards recovery, and also includes references to the relevant case law. So let's move on. When recovery is ordered. In this presentation, I focus on the public enforcement of state aid rules, as we say. It's when Commission orders recovery. And as already mentioned, the Commission has the exclusive power to determine whether aid is compatible with the internal market. When the Commission sees that aid has already been granted and this aid cannot be approved, then it adopts a negative decision ordering the recovery. This is an obligation on the Commission. It doesn't have discretion unless the recovery would go against the general principle of EU law. These general principles of EU law, there is no exhaustive list, but just to tell you, for example, res judicata or legitimate expectation are some usually grounds mentioned by beneficiary in a member state to prevent recovery. And when the Commission orders recovery, it adopts a decision that it's addressed to a member state, and this decision includes the obligation to implement the recovery. As I said, this is a scenario that the Commission orders recovery. Of course, we have other scenarios that can lead to recovery. For example, in case the Commission has approved the scheme under CSAF or under a tax scheme, let's say, then during the implementation, if there are errors in the implementation of this scheme to specific beneficiaries, then this is a situation that can also lead to recovery, and then the member state authorities are also required to recover the aid that was not granted in accordance with an approved scheme. But let's go back now to some principles of recovery that apply in general. So I will again stress that recovery is not a fine or penalty. In other areas of competition law, in antitrust, you may have heard fines imposed on companies, but this is not the situation here in state aid. The purpose of recovery, you can see it on the slide, is to remove the distortion of the competition in the internal market that occurred with the granting of incompatible aid. The advantage that the beneficiary enjoyed over incompetitors. And that's why recovery, when we talk about recovery, we talk about recovery of the full amount of aid plus recovery interest. The reason for requesting the recovery of interest is to cover this advantage that a company may have enjoyed over a period of time for having this free of charge an amount and using this amount, the amount of aid. And a few words about procedure. So recovery is ordered by the Commission in a decision, but is governed by national law, and it must be immediate and effective. The Commission sets in its decisions specific deadlines for recovery, and usually this is a 4-month deadline. This means that the member state has 4 months to recover the incompatible aid from all beneficiaries. So now let's see directly the impact of recovery, first on national authorities and then on the energy sector and companies. So recovery, of course, creates substantial administrative and political challenges for national authorities. When national authorities deal with the recovery order, they need to identify the beneficiaries, so who actually benefited from the aid, and calculate the aid amount that need to be recovered, and then quickly enforce the repayment of the aid. In this process, as you have seen, there is a very short deadline. 4 months is not a lot of time, so we must ensure that national law allows for this quick implementation of recovery. Obstacles in recovery left, I will mention a process as well, and there is often with energy keeping to raise emissions report payments of vertical from they have to imagine if the aid has been granted for a long period, then the interest is also a high amount. So this can create liquidity risks for the company. You have already heard that yes, when a measure is incompatible with the internal market, it has to be abolished. That means that it's possible that the contract has to be revised, the conditions may change. And I wanted also to mention here that legitimate expectation is an argument that rarely succeeds. So a beneficiary cannot really claim that they didn't know that the aid was unlawful and that the member state, by granting the aid to them, created legitimate expectations. The case law of the court is very strict in applying this principle, and it had ruled that this can only be accepted in very exceptional circumstances when the Commission has granted specific assurances to the beneficiary. A diligent operator on the market should check and know that aid, if a company receives aid, that this aid was duly notified and approved by the Commission. And of course, recovery is challenging for the company. I already mentioned liquidity, litigation risk. Of course, we have the private enforcement of state aid or national enforcement before national courts. Competitors can bring claims and courts requesting damages. And reputational concerns, state aid cases may end up in headlines in the press, and this can have some reputational risk for the market standing of companies. I also wanted to mention that we have some case law that also states that companies that have received incompatible aid and have to repay that aid may not be eligible for new aid. So, of course, you see this is a constraint that a company may be required to repay previous aid in order to receive new aid. And with that, I want to conclude this presentation and summarize the core messages. So for today, recovery aims to bring back fairness of the market. Again, I want to say this is recovery is not a sanction; is a correction on markets. So compliance is must delay. Strategic risks are also significant. So it's also important to keep in mind that proactive compliance is essential when it comes to state aid compliance and can prevent costly surprises and recovery. So with that, I thank you very much, and I give back the floor to Professor Metaxas, and I don't know if we have time for questions.